Hello and welcome to our Spotlight video series where we discuss cutting-edge employment law issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, a firm that helps people who've been fired or afraid they might be. I am thrilled today to be joined by Tyler Kohutanycz. If I got your name right, if not, you can correct me. Tyler is a second-year law student at Catholic University here in DC, and he works for our firm. So Tyler, first of all, to get your last name right, and then second, what's our topic for today?
How you doing, Tom? Thank you for having me today. You're very close. It's Kohutanycz, but no one gets it right the first time.
Or even the third time in my case. That's all right. I get all kinds of weird pronunciations of Spiggle all the time, so I feel your pain.
Today I want to highlight something that I don't think a lot of wrongfully terminated employees think about, and it's mitigation of damages in employment law after you are unlawfully terminated. The basic idea of the mitigation and damages is that you have to be able to try and go and find comparable work with reasonable diligence. An overarching idea about a mitigation in damages is to make sure that people are going out and actively trying to find work, and also that they're trying to find work that is comparable to theirs. So for example, a CEO of a company doesn't have to go and get a job at McDonald's to successfully mitigate their damages, but they have to show some sort of effort into finding that new job.
Yeah. So essentially you can't, I think it's a very important point, you can't sit on the couch and eat bonbons and, wait for your check. And in fairness, I don't think, I can't say that never happens, but I don't think most people, they're not doing that, and they want a new job and are going to look to find one. I think, as you point out, you can find something that, you don't have to look for something that is, different than what you are doing now. So the fact that, you might turn down an offer for a job that's, say, that you're overqualified for, or it's not a good fit for you, does not mean you're not mitigating damages. I think one really important practice tip or pro tip is that you want to, it's, when you've just gotten fired, and when you're looking for a job generally, it's, as we all know, like, you're doing a bunch of things. You're sending out resumes, you're going to networking events, and it's hard to kind of piece that together in retrospect. So I think if you keep that in mind, if you've just been wrongfully terminated, just keep a journal, just keep a Word document. Or if you're really, if you're into spreadsheets, keep a spreadsheet, so that you remember all these things. Because as you and I were talking about off camera, defense counsel will try to make a big deal about this. If your case gets to trial and once you're on the stand, they're going to cross-examine you on your efforts to find a job, and you want to be like on it. Be like, this is what I did, this is what I did, this is what I did. Because they're trying to paint a false picture to the jury that you're just lazy, right? Which is not the case. So I think that's a good one. So what else? Any particulars you think people should know about?
I think that something that is important to note in this mitigation of damages realm is that it's not set in stone, and there's not a lot that is black and white. Courts will look into a lot of different factors, like your age, the skill set, like I said before, your overall health, and the overall job market, and that will very much determine on what is reasonable, what's comparable, and what's not. So if we're going through something like, I don't know, a recession or something, a court's not going to come down with a hammer on an employee that was really trying to look for work, and just because of outward circumstances where it's not able to. The main point of this mitigation and damages is it's reasonableness. It's making sure that the court and the jury can see that there is reasonable efforts to be able to get that job. Success isn't necessary, but we definitely want those efforts shown.
Yeah, no, that's a good point too. Yeah, it's not, they're not expecting you to be a magician and make jobs that don't exist. They're going to take a lot of factors into consideration. Again, I think most people are, they want a new job. So, but I think one of two things. Like, first, don't make the litigation some people, understandably, when they're going through this, they discover their inner lawyer, and they really get into their own case, which is not necessarily a bad thing, but you don't want that to be your overriding concern, because again, defense counsel is going to ask you, you're going to have to show that you made efforts to find a new job, and that when you're doing this, particularly if it is, in a recession, that you're documenting your efforts to look for something, and take notes on. Again, it doesn't have to be a novel, just brief notes on, the fact that you sent out 100 resumes and you hadn't got any interviews, because it's a recession. And I think in rare circumstances, and this would be something your lawyer would work on, you can put on an expert on the stand, somebody who, kind of an occupational, experts, an economist, or any number of kind of experts you can put on the stand to talk about, the job market. Although you don't necessarily need one. I mean, most people know, particularly if there's a big recession, we were, COVID, that, your sector shuts down, whatever it is, people are going to know that. And so you don't necessarily have to put on an expert, to prove that. Well, Tyler, thanks so much. This is a very important topic. I appreciate you taking the time to educate us about it. Now I'll let you get to the next thing on your desk.
Thank you very much, Tom. Thank you for having me once again. I appreciate it.
It was a great job.